Assalamualaikum and a very good morning, everyone. Today we're going to talk about the answer for tutorial question of subsidiary legislation. For the intro, subsidiary legislation is a legislation made by lawmakers, the government ministers, or public bodies, though the powers are given to them by the acts of the parliament. It is also known as delegated legislation. Section 3 of the Interpretation Act 1948 and 1967 Act 338 defines subsidiary legislation means any proclamation, rule, regulation, order, notification by law, or other instrument made under any act, enactment, ordinance, or other lawful authority and having a legislative effect. Moving on to the four methods by which subsidiary legislation can be controlled. Firstly, through the process of consultation. Before a subsidiary legislation is introduced, the relevant individuals or bodies who are going to make the law must first seek all prior consultation from relevant advisory bodies and interest groups who are involved with the subject matter. This must be done before the subsidiary legislation is finalized. Some Parent Act makes a requirement for the consultation to be compulsory. If this process is not being followed, then the subsidiary legislation can be said to be ultra vires and becomes void. In the case of Ramachandran, Appalanaidu and others, and Datuk Bandar Kuala Lumpur and others, in this case, the Court of Appeal stressed that the general principle of statutory interpretation for subsidiary legislation is that subsidiary legislation may not be broader than the enabling legislation. In Malaysia, that the act which provides any subsidiary legislation is codified in Section 23 of the Interpretation Act, which provides that any subsidiary legislation that is inconsistent with the Act, including the Act under which the subsidiary legislation was made, shall be void to the extent of the inconsistency, and the effect of the Section 33 is a plain fight stop. Subsidiary legislation that is inconsistent with the Parent Act shall be considered as void. Second mode of controlling the subsidiary legislation is through the process of parliamentary control. Under parliamentary control, there are two methods that the parliament can use, which the parliament may exercise control over the subsidiary legislation by repealing the parent legislation or the subsidiary legislation act itself. Another option is the parliament through the Parent Act requires that the rules or regulation made under it to be laid before the Parliament. Under this method, the rules or regulation will only become effective if only there is no negative resolution against it by the Parliament. Some Parents Act makes the requirement for the subsidiary legislation to be approved by the Parliament for it can be effective. In this regard, the subsidiary legislation will only be effective when an affirmative resolution is passed by the Parliament. Moving on, the third control is through judicial review or judicial control. In Section 33, Clause 1 and 87, Parity of the Interpretation Act states that if a subsidiary legislation was to provide laws which are not consistent with an act of the Parliament or state enactment shall be void to the extent of the inconsistency. That inconsistency can happen substantively and procedurally. Here, the court have the power to declare the exercise of the delegated power and the subsidiary legislation to be void under the ultra vires doctrine, as the court, through the judicial review, have the power to control the subsidiary legislation. For example, when accused or defendant raises a defense in action or an aggrieved person challenges the validity of the subsidiary legislation, the court may declare an exercise of the delegated power and the subsidiary legislation to be void under the ultra vires doctrine. It may either be ultra vires or ultra vires procedural on the field of the substantive. It is here that the courts can exercise control over subsidiary legislation on the basis of their jurisdiction over the judicial review. In the first place, a question may arise as to whether or not the parent statute, which delegates the power of the subsidiary legislation, is constitutional in itself. If the law made under the subsidiary legislation is ultra vires with the parent act, it can be brought and challenged before the court. Here, substantive ultra vires is refers to the power which go above the parent act. When the delegated power conferred go beyond their limit, this refers to the case of Major Pang Yat Fu and Brigadier General Datuk Yahya and Anwar. From the proceeding, the High Court ruled that in Section 63, Clause 3, it was void to the extent that it confers jurisdiction on the convening authority to approve. Furthermore, there is no general statutory provision that requires subsidiary legislation to be published in Malaysia. However, it is the general practice that the subsidiary legislation is required to be published in the Gazette and will come into force on the date of the publication or on other such date as specified. Subsidiary legislation must be gazetted. At federal level, required to be published in Malay and English in two parts of the Gazette, which are legislative supplement, where all the proclamation, rules, regulation, orders and bylaw, or legislative supplement B, where it contains all other subsidiary legislation. To conclude the questions, the answer for this question, there are four applicable methods in order to keep subsidiary legislation in check. However, I personally speaking, it will be not enough to prevent the abuse of the delegated power. This is because there are still lacunae in justifying the subsidiary legislation in which it might be ruled arbitrarily unjust. With that, subsidiary legislation still remains essential in promoting a better legislative flow in the time of need. Thank you.